Hi, everyone. Good morning. This is Carol Williams with Williams Immigration, and I am back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. Usually we talk about things that have happened in the past week, but sometimes, as you know, oftentimes, with immigration, things don't progress in a week. So we've got things that are sometimes outside of the week. So, I like to dive right in. The first thing I want to talk about this morning are L1s. So these are L1As and L1Bs. These are my intra-company transfers. These are folks that are moving from one company overseas to a related company in the U.S. U.S. has issued some policy manual clarification and guidance for us and for the adjudicators. And so what they have said is a sole proprietorship may not take advantage of an L1. So if you are a sole proprietorship trying to take advantage of an L1 on behalf of the owner, the Immigration Service has indicated that there's not really a legal separation between the sole proprietorship and the owner. So those business entities are no longer or are no longer eligible for L1. However, I know when I started reading that, I got a little freaked out, but what that does not include are corporations or limited liability companies or LLCs with a single owner or a single member. Those entities are eligible for L1s. So if you are a self-incorporated petitioner, such as you set yourself up as a corporation or an LLC with a single member owner, that is still eligible for an L1 because legally there is a distinction between the owner and the business. So I will say when you are looking to set up in the U.S., and I work with companies that are outside of the U.S., they're looking to move inside the U.S. This is why we work closely not only with myself, but I also get them in touch with a corporate attorney so that they can make sure that their business entity makes sense not only for the business and running of the business, but it also makes sense for immigration purposes. So that is what has come out of USCIS last week for our L1s. They were super busy. Also coming out last week, individuals who are citizens and nationals of Israel are now eligible for the visa waiver program. They can use ESTA. That went live last week. So the announcement indicates it happened on the 19th that ESTA, the online system, was in fact updated to allow citizens and nationals of Israel to apply to travel to the U.S. for tourism for up to 90 days without having to first go into a U.S. consulate and get a visa. Now, if you are a national or a citizen of Israel and you already have a B1, B2 visa in your passport, you can absolutely continue to travel in and out of the U.S. using that B1, B2 visa in your passport. So that B1, B2 remains valid until its natural expiration date on the visa. So you just keep that in mind. You don't have to now switch gears and go to ESTA. So that will give some folks a little bit of a break, so they don't have to immediately go and register through ESTA. When you're coming in using ESTA, just a reminder, you want to make sure that you have either a round trip meaning going back to Israel from where you started, or an onward ticket, meaning maybe you're not going back to Israel, maybe you're going to a third country. So the U.S. definitely wants to see that you have a ticket that takes you on a date certain out of the United States, whether you are going back home to Israel or you're going to a third country. The U.S. Officers at the airport will definitely want to see that. And in order to use ESTA and be eligible for using ESTA, you must have a biometrically enabled passport. So make sure that you have that as well. Next thing I want to talk about are, on Friday, we got another Friday surprise, y'all. It's been a minute since the Immigration Service has announced something on Friday for us. They have given us an advanced copy they released of changes or proposed changes to the H-1B rule. Those should be published today. The proposed rule, it's not rule yet. The proposed rule is over 200 pages. So they took some time, y'all. They dug into the H-1B. They heard our comments as outside attorneys. They heard the comments of the employers who are employing H-1Bs. They heard a lot of comments. So they went in, they dug into this, and we now should, hopefully today, have a proposed rule. It is looking to enhance the integrity of the H-1B system as a whole, hopefully preventing misuse of the H-1B cap registration system, looking closely at the definition of specialty occupation. It's also in this proposed rule. Looking at F1 students, how they are impacted by the current policies under H-1B and their cap protections. And they're also really looking to, among other things, again, it's over 200 pages, to clarify for companies and for the employers and for us as outside counsel, when is an amended H-1B petition needed? These are just some of the highlights. These are super high level in what is in the proposed rule. Again, it is over 200 pages. I, for one, did not read all the pages this weekend. I thoroughly admit that. So these are high level. I will obviously be digging into this rule and we'll have more information on it for you. At this point, however, it is only a proposed rule. So as of today, everything is still the same. This is a proposed rule. There's a 60-day comment period. What we as a whole are sort of unsure about is whether some of these provisions or all of these provisions will be affected for the next H-1B cap season. And y'all know I talk about H-1B cap season for months. So I will be keeping a close eye on this proposed rule, be giving you updates, digging into certain sections that I think y'all will find interesting and helpful as we start to enter the next H-1B cap season, which is in my world always right around the corner. But I will keep y'all up to date on if anything in this proposed rule will become effective and will impact the next H-1B cap season. But I wanted to let you know this proposed rule is out there. It should be published today, so we'll keep an eye on that. Next up, so we've been talking and I've been giving you updates on visa revalidation. At least that's what it was called when I started practicing, a zillion and 1 years ago. So Department of State is expected, hopefully, to start doing visa renewals in the United States such that individuals do not have to go home, go to a consulate, get an appointment at the consulate and renew visas. We're hoping they will start that maybe in early 2024. We don't have concrete details yet. We are optimistic. It is winding its way through the federal government system. I suspect it will only begin with H-1Bs. I suspect that because it was sent to OMB and the title that this, rule went to OMB was, or is, I should say, pilot program to resume renewal of H-1B non-immigrant visas in the United States for certain qualified non-citizens. So because they have specifically put H-1B non-immigrant visas in the title, leads me to believe it will start only with H-1Bs. Previously, we were a little optimistic it would include Ls in there. It still may, I don't know, but we will see what we see. But I wanted to let you guys know that that has made some movement within the federal government. So hopefully we'll see something on that soon. Next topic for this morning is the diversity visa registration. That is open, y'all. If you are looking to register and enter that lottery, the time is now. It opened on October 1st. It will close November 7th. So keep that in mind. Again, y'all, this is technology. It's a well-traveled piece of technology for the Department of State, but you never know. Glitches can happen on your side or on the side of Department of State, or when the system you're trying to log into maybe isn't working and your computer's not working, your ISP is down, whatever, right? So do not wait until the last minute. Do not wait until the last minute. And the last minute is November 7th. So diversity visa lottery, if you're looking to enter, please do so, but make sure you do so before November 7th, which is the day that the lottery registration closes. So just keep that in mind. I've got an update for you regarding the U.S. Embassy in Jerusalem and the Embassy branch office in Tel Aviv. I want to simply read to you the note that is on the current website to that embassy in Jerusalem. And it says, due to the ongoing security situation, the U.S. Embassy in Jerusalem and the Embassy branch office in Tel Aviv are not offering non-immigrant and immigrant visa services at this time. If you have an emergency need to travel to the United States and do not currently have a non-immigrant visa, please apply at a U.S. embassy or consulate other than Jerusalem or Tel Aviv. Consular sections at U.S. embassies and consulates worldwide can assist with expedited appointments for emergency travel. Please make an appointment and request an expedited appointment in that country. This is the note that is currently on the U.S. Embassy in Jerusalem's website. This is the most up-to-date information that I have, so I wanted to pass that along. Consulates all over the world are able to expedite emergency travel appointments. So please keep that in mind. But when and if this note changes, I will let you know. I am certainly checking it continually. The last thing I wanted to talk about this morning is another national interest waiver tip. So we know that the national interest waiver is a green card category. It is the second preference category. Being a second preference category, it requires a master's degree or higher. You may also qualify under extraordinary ability, but you must then show that your proposed endeavor has substantial merit and national importance to the United States, that you as the individual applicant are well positioned to advance that proposed endeavor, and third, that on balance, it would be beneficial to the United States to waive the requirements of a job offer and the labor certification. As we know, the labor certification is a process that we work with through the Department of Labor, where we advertise for qualified U.S. workers. So the tip I have for you today is, what exactly does well positioned to advance your endeavor mean? It means, do you have the skill set to say and to achieve what you say you want to achieve, right? So the Immigration Service is going to look at a couple different things. They're going to look at your background skills. They're going to look at your background education. They're going to look at your specific experience in the field. If you say you want to be the next, king of semiconductors, but you don't know what a semiconductor is, you've never worked with a semiconductor, there's nothing in your history that says that you have the skill set, the education, or the capability, the Immigration Service is going to have some questions for you, right? So you want to make sure that you can show that you have the education, the background skills, and the experience. The Immigration Service will also look at what have you done previously? What's your prior experience in this particular endeavor? What success have you had with this endeavor? Now, maybe you haven't had success in this exact endeavor, but you've had success in something that is similar, and you're sort of working, and what you've had success in is kind of sort of related to what you want to do, in the future. That might work, but we've really got to document that because the Immigration Service is looking for that. And this is what I say to a lot of people that I talk to about national interest waiver. Do you have a plan? Do you have a plan? If the plan is currently only in your head, that's not going to work for the Immigration Service. They need something on paper. So what is your plan? Is it written out? Do you have a business plan? Have you really thought out the nitty-gritty details to your proposed endeavor? And the other thing the Immigration Service finds compelling is, are folks asking for your proposed skill, service, or product? Do you have a built-in client base? Are you already at market? Are you already doing what you say you want to do as part of your national interest waiver application? So those are some of the things that the Immigration Service looks for when they are evaluating the second prong of, are you well positioned to advance your proposed endeavor? So that is all I have for y'all this morning. If you have any questions about your immigration case, if you are looking to hire somebody, you have found that right candidate, and they happen to not be a U.S. citizen, if you have questions on how to get that person the right work authorization, you are absolutely welcome to give my office a call, 954-903-1337. You can pop me a note on this platform. We do check those. If you found this helpful, please feel free to share it with a colleague. This has been another beautiful Monday morning. Have a great Monday morning and a great rest of your week. And I will, of course, be back next Monday with any immigration updates. I am Carol Williams with Williams Immigration. Have a wonderful